Having introduced the monist and dualist systems, I now want to dig a little deeper and speak about some practical instances in which questions regarding the judicial enforceability of international legal obligations in domestic orders has arisen. I'll firstly talk a little bit about key concepts such as direct effect, direct applicability, before then discussing the two specific examples that are also mentioned in the chapter of the textbook, namely on the one hand the European Union and its special legal order, and then on the other hand the US Supreme Court judgment in Medellín. As you will see in a second, the concepts and examples discussed here relate more to the monist approach to incorporating international law, which makes sense, of course, because if you think about it, in a strictly dualist system, the question of the judicial enforceability of international legal norms does not even arise. These are two separate legal spheres, and domestic courts in a dualist system do not even see or recognize international legal obligations as sources that are applicable in its jurisdiction. There's one caveat though, and this concerns the interpretation of the implementing domestic legislation. As already said at the end of the previous video, what courts in dualist states try to do is to align the interpretation of the international instrument with the one of the domestic implementing act. And in this sense, don't be surprised if you find a reference, if you find a citation to the international legal source in a judgment of a dualist court. This most likely will be in order to understand better and interpret the provisions that are in the domestic legal act. Moving on to the monist systems, if we want to understand how international legal obligations are enforced by domestic courts in practice, we need to understand the concepts of direct effect, direct applicability, and the self-executing treaty. Now, as Klabbers rightly points out, these three different terms mostly refer to the same thing and are used interchangeably. In the European context, we talk more about the direct effect and the direct applicability, and in the US, to stay with our two examples that we'll discuss in a second, we talk more about self-executing and non-self-executing legal obligations. So what do these terms mean and imply? Well, basically they designate a specific category, a type of international legal obligation, namely one that can be directly used and applied by a domestic court in a monist system. And now you might wonder and ask, hey, wait for a second, was not that the very definition of monism, that we can directly apply international legal norms in a domestic legal order? Well, that is correct. However, in a monist system, we usually draw distinctions between those norms that can be directly applied and other norms that do not qualify as such because they do not create rights and obligations that courts can directly use in order to come to their decision. More specifically, provisions that do not have direct effect, direct applicability, that are non-self-executing, are usually addressed to the legislator, either implicitly or explicitly, giving them the task of implementing legislation, a little bit akin to what we see in dualist systems and what dualist systems require by default. However, in a monist system, we also have these other kinds of norms where rights and duties, in particular for individuals within the jurisdiction, are directly created and that therefore do not require this intermediary step, do not require the legislature to step in and create acts that would give effect to the obligation in question. As the textbook relevantly points out, one expression of the direct effect is that it can create private causes of action for individuals, for legal entities such as companies, in which they can use this provision as an actionable right vis-à-vis another entity, for example, the government. But this is not the only way in which direct effect comes to be relevant. In certain cases, it can also be used as a defense or a shield. For example, when an individual faces criminal prosecution that then, however, would go against this international legal obligation. Even if there's no actionable right here, the individual can still rely on it as a defense in order to not be criminally liable. To illustrate how this works in practice, let's look at two specific examples. The first one being both historic and famous, namely the European Court of Justice's landmark decision in Van Gent and Loos, where it was confronted with a preliminary reference by a Dutch court. The Dutch court basically asking whether a Dutch shipping company could rely on the European treaties in order to challenge a custom duty that the Dutch government had instated in contravention with these treaties. Now, what the court decided was very remarkable, particularly back then in 1963, but even from today's perspective, in that it decided that the European treaties, the European community had, and I quote here, created a new legal order of international law for the benefit of which states have limited their sovereign rights and the subjects of which comprise not only the member states but also their nationals. And this in fact confers upon these individuals rights which become part of their legal heritage. So in plain words, the court decided that the treaty and the prohibition of the custom duties in the treaty had created an actionable right, had created a private cause of action for the individual, for the transportation company in question, and which then the domestic courts in the Netherlands had to apply. Now, in the Dutch context, that was not so much an issue, perhaps because it's a monist state anyways, but it was revolutionary in the sense that even those states within the European community that were dualist states, or still are, were still forced from that moment on to, in fact, take into account European Union, European community back then, law in their domestic legal proceedings. Now, apart from basically forcing monism even onto dualist states and creating a direct effect and direct applicability in principle for European Union law across member states, the court did another really important thing in this ruling, namely to clarify that not all provisions actually qualified as such. Only when they were specific enough, when they were clear enough, and when they were actually unconditional, did they actually bring about such direct effect. The second example given in the textbook hails from the United States and goes to show how even within a monist system, a domestic court is actually able to use the distinction between direct effect and not direct effect, or in US parlance, between self-executing and non-self-executing treaty obligations, in order to limit the effects, the impact that international law can have in a domestic legal setting. In this particular case, Mr. Medellín had been sitting on death row in the United States and had claimed that he had been denied consular assistance by his home state, Mexico. In this claim, he relied on a previous decision by the International Court of Justice in Avena, where the court had been confronted with a very similar question and had found that the United States, in denying this kind of consular assistance, had breached the Vienna Convention on Consular Relations. So the US Supreme Court now was faced with the question whether this ICJ judgment could in fact be invoked in the US legal system, and it came to the conclusion, it answered this question with a no, saying that in fact ICJ decisions, just like the optional protocol, just like the UN Charter, just like the statute of the ICJ, were non-self-executing, meaning that individuals could not invoke them in court. The fact that this had been a repeated breach by the United States of the Vienna Convention, and that in fact in Article 94 of the UN Charter, member states are obliged to comply with judgments of the ICJ, all of this did not matter. What's important to take away from this judgment is that even in a monist system where domestic and international law are supposed to be one legal order, we actually do have often a practical barrier between the two. And the gatekeepers in this case are the domestic courts, which are using this distinction between, on the one hand, self-executing, directly applicable and direct effect norms, and on the other hand, those norms that do not qualify as such, to achieve outcomes that are in some way comparable to what dualism achieves with the strict separation between these two legal orders. This concludes the videos for this week. I really look forward to discussing these questions and some cases with you in class.